Hello and welcome to another episode of Webinar Wednesday. Today we have a super important topic. We're going to be talking about brand registry, trademarks, Amazon IP Accelerator program. That's super important for, I think a lot of new sellers have been asking about this, right, Mark and Kevin?
Yes, look, and I think it's really good to get the right information. I mean, this way you're going to know exactly what processes and how the trademark actually works, because it's very daunting when you start to do this to figure out how all this trademarking works. So I think it'll be great for everyone.
Yeah, g'day, Megla. We've got an excellent presentation today from Tina Lopez. She's in California, and she's hoping there's not going to be an earthquake there today.
Yeah, absolutely. But before we invite Tina to share her presentation, there are a couple of things that we wanted to talk to you guys about. First of all, the listing optimization workshop is going great. It is so awesome. What do you guys think about that?
It was brilliant. Yeah, and we did our usual. We're only an hour and a quarter overtime, so good value for money.
Yeah. Well, Verity's put together. Well, it's been a fantastic workshop, and the hard work that Verity's done behind the scenes with putting the content together has been awesome. And Verity is a really good speaker, really good presenter, and she knows the listing optimization because she's done it all herself, and so and she knows how to teach people too, and she's taught different levels of people from in companies and also just normal sort of people. So she's got the experience, and we thoroughly enjoyed the weekend and the interaction that was through the whole thing. So marvelous, yeah.
Absolutely. And I also like the fact that she was actually able to review some listings and live during the workshop. I think that was really helpful. And a couple of people have sent her listings in the Telegram group as well. And I think that the call that we had this morning, the midweek follow-up call in the Telegram group, that was pretty good as well. So people could just jump in and ask any questions that they have. She's given a lot of homework, hasn't she?
Oh yeah, yeah. But the other side of it too, it's opened up other things for people to to see live and be interactive with it. I mean, Amazon is a journey after all. I mean, you can't learn every step in a week. It's a progressive sort of thing, and listing optimization on its own is there's a lot involved, and it's it's some serious learning at times.
Absolutely. Right. And the other thing that we are really, really excited about is the upcoming PPC workshop. So we've been working with Ritu Java from PPC Ninja. And again, this is a topic that a lot of people struggle with. So mark these dates, everyone, March 13th and the 20th. This is if you're watching or if you're joining the workshop from Asia or Australia, these are the dates. If you're watching or joining the workshop from the US, then that will be March 12th and the 19th. So these are the dates for the upcoming PPC workshop, and we'll be announcing more details in the group very, very soon. Really looking forward to this one as well.
Yeah, for sure.
Okay, awesome. And then lastly, we've got VIS coming up later this month. So we are making a slight change in the VIS dates this month. So instead of doing VIS on the last Friday and Saturday of the month, we're going to be doing it on the last Thursday and Friday. So February 25th and 26th. Those are going to be the dates for VIS this month. So keep a lookout for that as well. Okay, so let's get moving. I'm going to invite Tina on stage here. Hello, Tina. How are you?
You're muted.
Hi, how are you doing?
Good, Tina. How are you?
Hello, Tina.
Good. I'm so happy to be here. Thank you for having me, Megla, Kevin, Mark. I'm really excited to be speaking with you all today.
Great to have you here.
Yeah, awesome to have you here, Tina. I mean, we get so many questions about brand registry and trademarks, and especially a lot of newbie sellers. So we are so excited to learn more about this from you. So I'm going to go ahead and share your slides, and you can take it away. And guys, if you have any questions along the way, type them in the comments. Tina will be answering all of the questions. She has a presentation that will take about 25-30 minutes. And she'll also be taking some questions during the presentation, but we'll take most of the questions after the presentation. So do write them in the comments. Okay, let's get started. So Tina, just let me know when you want me to change the slides.
Great, thank you. I'm Tina Lopez. I am actually the founder and managing partner of my law firm, and my law firm happens to be one of the IP Accelerator law firms. And so I think that's why I'm here today, to kind of talk to you not only about my perspective about trademarks, which I think were important before Amazon existed, because a trademark is an important thing, a foreign property before Amazon was even a part of our lives, but also to talk about it in the Amazon context. And so I hope I can give you some really great information about that. My website is there, and I hope that I can answer any questions for you guys as we go along. So happy to be here. Thank you. My firm was started in 2005. It's minority and women owned. That's important to, well, in the United States, it's a very important topic, but I'm very proud to own this firm. It's an IP firm, so we don't just do trademarks. We do patents, copyrights, litigation, things like that. Have about 40 attorneys. I'm located right now, I'm sitting in Southern California, where it's sunny and beautiful. But I have attorneys all over the country. And we were actually one of the first 11 firms that were in this program. So I've been in this from the start. This started on October 19th, and I think they had a couple firms doing a little bit of a pilot to play with it right before October. But pretty much this kicked off in October 2019, and we got the wake up of our lives with thousands of Amazon sellers looking to trademark. So it's been a very interesting year plus now, and it's been good work and really enjoyable. So next slide. Just so that we're speaking the same language today, I really like to give a little bit of an overview of what the difference is between patent, trademark, and copyright, just because it's important to know all the different ways that you can protect yourself. And it's also, I think, important when you're talking with an attorney to kind of have an idea of what you're saying, because sometimes the languages and the different terminologies get mixed up. And so it's good to kind of have a good basis to speak from. I call this the trifecta. It's sort of my day-to-day of what I, every day encounter. And actually, we often encounter all three of these things with Amazon sellers. So it's pretty common. Patents are things that you invent that you can protect, right? So a utility patent or a design patent, it protects new, useful, and non-obvious inventions. So you come up with a new rotating spaghetti fork, and you don't want other people to make the rotating spaghetti fork. You file a patent application for it, and you can prevent others from making, using, selling it, importing it, right? So that's the whole point behind a patent. There's also design patents, which actually a lot of Amazon sellers have been looking into. And it's not the way something works, it's the way something looks. So I'm not protecting the way that a tire works or a wheel works, but I'm protecting the way the wheel looks. So if a wheel has a certain look to it that's kind of cool, and you're putting it on a car and you want your ride to be pretty sweet, then you get these cool wheels. That's what I'm protecting, is the way that the wheels look. So that's a design patent. Trademarks protect source identification. So that's really what we spend a lot of time choosing a brand name for. When you hear Amazon brand name, that's what you're talking about, is a trademark. It protects the source identification. So let's just go with a very simple source identification, McDonald's. Everybody knows that the golden arches means McDonald's. If you go there, you're going to get a cheeseburger and some fries, and they're going to be McNuggets, and all of those things are tied into McDonald's, and the source is McDonald's. So that is what a trademark is. Copyright protects the way a words to a song, your blog, your content, your instruction manual, drawings, things like that. We don't see as much copyright in the Amazon space, but it does come up from time to time. And so that is that category. It does not protect a logo. So if there is a design mark that is associated with your trademark, it could be a trademark, which is your source identification. And it could also be a copyright if it was created by you as a special graphic design. But really what you're going for is a trademark for Amazon purposes. But you might end up falling in more than one of these boxes, right? So that's sort of the overview of all three forms of intellectual property that you might encounter, with the most important that we're talking about today, and my personal favorite, trademarks. So next slide. A little bit about trademarks. What's the point? And I think that before Amazon was the thing that people got trademarks for, people were getting trademarks because it's important to protect your brand. You're building goodwill in something, and that is an asset of your company. And when you sell that company, assuming that you plan on selling because it's become so profitable, that asset has a value. And if you take that asset away, it ends up being something that is not as valuable, right? So the function of trademark is to add value and goodwill to a name, an asset. And you use that asset in a way to identify and distinguish from other marks. So you have McDonald's and you have Carl's Jr. or whatever it is, and you're able to distinguish the quality and know what you're getting when you're associating with that particular thing. So if you're buying Levi's jeans, you know what to expect from your Levi's jeans every time you pick up your 501s, you know your size, you know the wash, you know exactly what you're going to get when you pick up your jeans. And that's because they've created a trademark and it's known that all the goods that come under that trademark are going to be exactly the same. And that's what trademark accomplishes. And once you have that, you can prevent confusion by sticking to the way that it is. So it's super important to make sure that the quality associated with it is the same and consistent over time. What are the benefits of a federal trademark registration? You're giving notice. So if you're looking up a trademark, you can find it very easily in public sources in pretty much every country, right? So the United States, you go to the United States Patent and Trademark Office. Canada, you go to SIPO. Europe, you go to EU IPO. I mean, all of these things are public, and that gives notice to other people that you exist so that when a trademark attorney is searching to see if there might be a problem, they can find you. So it gives notice. It allows other people to know that you exist. It's evidence of your ownership. In the United States, it gets you into federal court. You don't want to be fighting about your trademark in state court. You want to be in federal court because you get extra rights. So that's super important. A U.S. registration can be used as a basis for registering in other countries. So you can file in the United States, and within 6 months, you can use the Madrid Protocol and claim priority to your U.S. application to file in several other countries. In the United States, you can record your trademark with customs. So if you're shipping into the United States and someone else starts knocking you off and shipping their goods with the same trademark in the United States, it can be stopped at customs. Which means that a whole bunch of stuff sitting at the port if it doesn't get in, that person is not making any money and you're stopping them at the source. So that's super important for people who are importing the goods. Finally, and this is more recent, so this bullet point has become more recent in this presentation in the last 5 to 10 years, is that you can use that federal registration not only on Amazon, but you can use it on Facebook, Instagram, eBay. All of those places have a form that you can put your federal trademark registration in and stop other people from using it on those social media sites. So it's super important in it. And often if someone can't find you on Facebook, Instagram, then they no longer have a source. There's nobody else's, no one can find them. So, that is super helpful when you don't want to file a lawsuit. If you could just pull somebody off of Instagram or Facebook, it's a cheap and easy way to use your federal registration, right? A question that I get probably every day is what's the TM versus the R? The R just means that the trademark is registered. The TM you can use whenever you want. So as soon as you start using your trademark, you can start putting TM next to it. R is reserved for when the mark has actually registered. And then finally, what's trademark infringement? We hear about trademark infringement all the time. Trademarks are a consumer protection tool, right? So ultimately, trademarks are just there so that we can prevent consumer confusion. And so when you're looking at a trademark and what trademark infringement is if someone is creating confusion, they're a trademark infringer. So if there are two similar marks being used with similar goods, they would be considered confusing to a consumer, and that second user, that later user, would be considered a trademark infringer. If you have two identical marks being used with totally unrelated goods, then that might not create an infringement issue. So two identical trademarks, one being used with cosmetics, one being used with auto parts, a consumer wouldn't be confused, because usually the people who make cosmetics and the people that make auto parts are not the same. So they wouldn't be confused as to the source of the goods. Now, this gets a little bit tricky on Amazon because you have people selling many different kinds of goods sometimes. And so that complicates things a bit, especially since Amazon brand registry, if you have one brand, you can list a number of goods under that brand and sell under that brand, even if it's not in your trademark application. So those are things to kind of consider, and a basis on trademark law and what the point of this entire thing is outside of Amazon, what you get with a trademark. I hope that's a good background. Do we want to go to the next slide?
Yeah, I think so. I mean, are there any questions from anyone so far? If you have any questions, just type them in the comments. I don't see any questions yet. Some people are just saying, looking forward to this, looking forward to this. Do we get the slides? Yes. So I will post a link to the slides in the post description after we are done. Okay, so we don't have any questions so far. I think we can keep going.
Perfect. That's wonderful. Okay, so this slide is now getting a little bit more into choosing your trademark, and choosing it in a way that makes sense, not only for choosing a good trademark, but also for choosing one that's good for purposes of Amazon. And I'm trying to be a little bit more specific here, because sometimes there's a couple little weird things for Amazon that don't necessarily apply all the time for all trademarks. So a couple things to keep in mind is if you're choosing a trademark, do a search first, do some due diligence, basic due diligence, go on Google, make sure no one else is using the same thing. You don't want to choose something that 100 people are using, because then you're not really creating goodwill in your source. You're not creating a brand that's not going to be confused with people, with other people, right? You want to try to pick something unique. You can also, again, like I said, the USPTO has a search engine for trademarks. You can go in there. If you put in your trademark and you get a lot of results, that's something that should concern you. If you put in your trademark and you start to look at the results and there's a lot of results that are in the same field as yours, that should be concerning to you, because ultimately at the trademark office, someone's going to review your trademark, and if they see a similar or identical mark being already registered with identical or related goods, they're going to reject your trademark application, or you're going to send it to me and I'm going to tell you, you're never going to get this trademark application. You've now paid me. I've told you you're not going to get it. You have to choose a new mark. So just some really smart due diligence will go a long way, will save you a lot of money, a lot of headaches. So definitely do some Google and USPTO searching on your own before you settle in on a mark. Trademark choice for registration and Amazon purposes specifically. The first bullet point is important for everybody, right? The more arbitrary a mark, the more likely you're going to be able to get it registered, and the stronger the mark is. So the perfect example that we always use for this is Apple for computers. Apple has nothing to do with computers. It doesn't communicate anything to the consumer about what the thing is. And so it's completely arbitrary and therefore a really strong mark. Now, when you don't have the product right next to the mark, it doesn't communicate anything about the product, which means you have to educate the consumer. That meant that Apple had some education that they had to do to get to the point where everybody knew who they were and their brand was a internationally recognized brand. So these are things and same with Amazon. Amazon for online retail stores. What does an Amazon have anything to do with online retail store services? Nothing. So it's a very arbitrary mark. So that's a good choice for trademark purposes, because the more arbitrary it is, the more likely that nobody else is using it for something similar, right? Avoid completely descriptive marks. So if the mark is completely descriptive of what you do, you will not get that mark registered. It will receive what's called a merely descriptive rejection. You want to avoid that. Now, let's say you send me a fairly descriptive mark, okay? Botanical solutions for your garden decoration planter, okay? That could technically be considered sort of descriptive. The person might say, well, it might go in a garden. What's a botanical thing? If somebody could make that connection as completely descriptive and not suggestive, that will get a rejection, called the merely descriptiveness rejection. Now, for Amazon, if you get a merely descriptive rejection, normally you could amend the application to what's called the supplemental register. But Amazon does allow marks on the supplemental register to remain on brand registry. So I'm going to tell you, listen, if you want to file this as a word mark, which is the best mark you can file, then you need a better mark. This descriptive mark is not going to work for you. The way we get around this descriptiveness rejection is by filing for your logo. It's not as strong of a mark, but I could file it for you, and that will get you around that merely descriptive rejection, and it'll get you around the supplemental register. So my advice is to try to avoid descriptive marks to begin with, right? If you have to choose the descriptive mark, or you've been using it already and you're really committed to it, I'm probably going to recommend that we file for your logo, even though it's a weaker mark. So those are just a couple things that, you generally want to avoid descriptive marks, but for Amazon purposes, there's some technicalities that are associated with that. Avoid surnames and geographical locations. Those also trigger rejections. Similar to that, there's merely surname rejections, merely a geographic location rejections. So let's avoid those kinds of things. Try not to choose the city that you're living in. I got an application the other day of a city. I didn't know of the city. I'd never heard of it, but then I looked at the applicant information and their address was in that city. So I'm like, this is going to get a geographical rejection. Like, let's file for your design mark. Let's do something else, because I knew that was something that was going to get triggered. Could you scroll down a little bit, Megla? I want to show this example very specifically because it's important for Amazon purposes. If we end up filing your logo, it's important that your logo doesn't have letters in it. So I'm going to, not because it matters for the trademark office, but it matters for Amazon. So I'm showing you a mark, Qualitish, if you see that on the slide. And the logo that's associated with Qualitish is the Q, if you see that in the little black happy circle above it. The Q, Qualitish, that is called a literal element. So if you see the word mark underneath the design mark, that's pulled straight from the USPTO. So the literal element of the mark is not just Qualitish, it's Q Qualitish. While Amazon looks at that and they don't just see Qualitish like all of the other people in the world, they see Q Qualitish. And they say your Amazon brand name has to be identical to the literal element of the mark, which means that this seller had to use Q Qualitish as their brand name. Now, this is not a big deal. You could change it very easily on your brand name. It doesn't change your reviews as far as I've heard. It doesn't change anything, but I have had lots of sellers get wildly annoyed by the fact that they now have to add their Q Qualitish, the Q, to the brand name on their Amazon brand name. They're like, that doesn't look professional. It doesn't look good. Da, da, da. I've heard all of it. I'm telling you now, if you're going to send me a logo and it looks like that, you're going to have to either remove it or just be happy with the fact the Amazon brand name is Q Qualitish. Okay. So yes, it's a weird thing. It's an Amazon thing. And I love to blame Amazon for it because it's their call. So I'm just letting you know now. And I think that covers that particular thing. Like in normal life, though, this doesn't matter. So if you really are dedicated to your letter and your logo, and you just really want a trademark registered, I am fully supportive of your letter being in your logo. It's just going to show up like that on Amazon. All right.
There are a couple of questions. Okay, sure. If you're okay. So Mark Cooper is asking, what is palming off?
Palming off is it's a form of infringement where you're trying to get away with so it's a form of infringement. When I say infringement, you're causing confusion because someone is trying to get away with saying that their goods are your goods. So that is what it's like a counterfeit situation, but they're palming it off. And so that's what that is. Any other questions?
Okay. Yeah, so there's one more question. If someone has trademarked a name, just words, and if someone else has a logo with the same name, will the logo pass through trademark registration?
No, it shouldn't, right? So the best and broadest mark that you can file is your word mark, okay? And if you file for your word mark, then the trademark examining attorney will not allow any similar marks, even if they look different, because the word mark is broad. It covers any way that it looks, any color that it might be, any font, any designs that might go with it, won't get around the fact that you have this strong, broad word mark. So you file that broad word mark, that's the best one you can get, and someone comes along and files that logo, they're probably going to get a rejection if the word portion is identical. If you file a design mark, that design feature might limit you. It's not as broad. So if someone else files another design mark and it has a very, very dissimilar design feature to your design feature, you might be in a situation where the PTO might let that go through. So that's why we always file a word mark if we can do it. It's the best and broadest mark to file.
Right. Okay, we have another question. Is it necessary to get all the categories we might sell on Amazon while applying for the trademark?
Okay, so the trademark office works in classes, right? So you file a trademark application in connection with goods and services, right? So class 25 is clothing, class 16 is paper products, class 3 is cosmetics, okay? Each one of those things are a separate class, a separate filing fee. Amazon does not care if we file in all those classes and you sell in all those classes. They just want one trademark with one listing of goods, so one class. And if you go ahead and sell other things, so let's say I filed a trademark in class 3 for cosmetics, and then I do brand registry, and I am in that process already with brand registry, and then I start selling clothing and backpacks, okay? And so I have those two other goods that are now selling. Amazon will let you sell any number of goods under that brand registry without necessarily specifically filing in those classes in your trademark application. So you're able to do that. Now, Amazon's cool with it. You can sell, you'll be on brand registry for all of the goods, but you may not receive the same level of trademark protection at the, to prevent infringers in the United States if you only file in class 3 and then you start filing, start selling clothing and other things. You might not be able to go after an infringement in clothing. So your trademark rights will not be the same as your Amazon rights. You still do have some rights, but they're not as amplified. They're not federal rights. They would be common law rights, and it would be a little bit narrower, unless I can argue that the goods are related. So it's just more limited trademark rights, but your Amazon rights are all there.
Right. Okay, so another question. This is a follow-up from the previous question. So how about if there is a difference of one letter between the two names?
Well, I consider when I'm doing a likelihood of confusion analysis, I sort of do it on a sliding scale. So the more similar the marks are, or if the marks are identical, then the goods can't be as similar, right? If the marks are very dissimilar and the goods are identical, there's no confusion. So that's basically, it's a sliding scale. So if the two marks are identical but for one letter, and they look the same and they sound the same and they have a similar commercial impression, even with the difference of that one letter, and the goods are either identical or highly related, I'm going to tell you to choose a new mark, because that one letter is probably not enough. And there's not a percentage of how different something needs to be. It's really a look, sound, meaning analysis. So people are going to say it the same way. If it looks pretty similar, it's probably going to get a rejection if the goods are highly related or identical.
Right. So guys watching, can I just request you to go to this URL, streamyard.com/Facebook, to give StreamYard access to your Facebook profile so that we can see who you are when you comment. Otherwise, we just see Facebook user. We don't see your profile picture and your name. Okay, we've got a couple more questions. So what type of trademark will be powerful? Word and logo together?
For me, powerful, I like to feel like we have power with our trademarks. I like that word, powerful. But ultimately, the best registered trademark you can have will be just the words with no logo. Now, if you're developing a brand in an appropriate way, you're creating a brand, you're creating a portfolio, certainly you're going to not only have your word mark, but you're going to have a logo, you're going to have different taglines perhaps that go along with your brand. You're creating a portfolio. You're not just doing a one and done. So you might have an entire family of marks, and when you have the budget, you should file for all of those. But the first mark that I'm going to recommend that you file is the best and broadest mark, which is your word mark. That is the most powerful one. You have to get that one.
Right. Okay, so we don't have any more questions. I think we can move on.
I like the
to the next slide.
questions.
Yeah.
Okay, so why are we bothering with this? I think that this is a group that already knows the answer to this question. Brand registry obviously has certain benefits. Megla, you can share this PowerPoint with everybody afterwards so that they can click on these links and very easily see it. I know it's very small for everybody to see, but obviously enhanced brand content is a big one. I think that's why a lot of people do the Amazon brand registry. Also, there are tools that you can use for infringement and other things. So all of the benefits are at that link. I'm already a few minutes over my 25 to 30, so I don't want to get into this too much, but you can go there. How do you find the IP Accelerator firms? You go to that link right there. There's 11 firms on that page. I happen to be one of them. If you go to amazon.losip.com, that'll take you directly to my Amazon page, which you see on the bottom right-hand corner. And so I'm happy to work with you there, but you just can click on that link and you could find access to all of the firms. And they're all really good. And so, I mean, we've had calls with all of them. We've seen them all. And I know that they're, getting good reviews. And so I think that Amazon's created a good little crew of people, and everyone is really excellent. Oh, next slide. Sorry. Like, why am I standing here? Okay, so next slide. I just want to give you a little timeline just to set expectations on how the process kind of works, because I think people get kind of overwhelmed by it. And I had this in bullet points at one point, and I'm like, I'm going to make it pictures because it's easier sometimes to kind of see how this plays out. Let's say you contact me through the seller portal on Amazon. I usually, me or someone on my team, I have 7 amazing trademark attorneys all working on this project. So we actually take turns. You might not get me the day that you go on the portal, but someone on my team is, and they're all fantastic. And so you click on the portal, you probably ask us a few questions. I send you a whole bunch of information. If you decide you want to move forward, I send you an engagement letter, and you pay your retainer. So that happens usually in the first day or two. If you're responsive, I'm responsive. Everyone on my team usually gets back very quickly unless we're sleeping. So it's sometimes the time change is a little different. I usually hear from Australia sometime, it starts around 1 or 2 in the afternoon here. So that sort of depends on where everybody is located. But I'm on Pacific Standard Time. There are people on my team, in Central Standard Time. There's, East Coast. So we have people sort of all over the country working on this team. So you'll get a response pretty quick unless we're sleeping usually. Once we have your signed engagement letter and retainer, you'll get a search from us. We always do a search because we don't want to file a bad mark for you. We want to file a mark that you have a pretty good chance of getting. And that's super important to us. It's one of our values. There are firms that do not do searches. We always do one. It's very important to us because we want to file a mark that we think you're going to get. And we at least want you to be highly informed if we think that you're not going to get it. Your expectations will be very clearly set. And we think that's super important for clients to be educated about what they're getting into. Once that happens, we also send you the filing details at the same time. If you review it and approve it, I file it. I usually file it the same day or next day. It's very fast. I file it. I report it to Amazon. Once I report it to Amazon, there's a 2-week period where you have to wait. And then you can self-enroll in brand registry. Amazon used to do it where they used to contact you. So if you did this program very, very early on, Amazon used to contact you. Now you self-enroll. We give you a link. We give you all the information that you need so that you can self-enroll. And then you're done. You're in. You're in Amazon about 2 weeks after we file. In terms of the trademark process, now that keeps going, right? So you're in very early because of the IP Accelerator program. Before this program, you had to wait until your mark fully registered. And that's why this is called an accelerator. Now you're not having to wait till it registers. You're getting on to Amazon Brand Registry, 2 weeks after we file. Registration, nobody even looks at your application at the trademark office for 3 to 4 months. All the marks that were filed in September, we are just getting responses from the PTO right now. So that's sort of the time frame at the Patent and Trademark Office. And usually, depending on the kind of trademark that we file, you're looking at a registered trademark in about a year. Okay, so that process is still happening while you're already on brand registry. Next slide. There's 2 different applications that we can file, use applications and intent to use applications. This is a little bit tricky. I like to give all the information so that you know exactly what you're getting into here. Use for purposes of the trademark office means, are you selling this stuff in the United States? Okay, if you're not selling it, you're not using it. So it's if your supplier has already sent you pictures of what it looks like, that's not use. It means that you have pictures. You have to be selling. So selling in United States commerce, that's considered a use application. If you're not selling yet, you can file what's called an intent to use application. There's no difference in cost between these 2 filings. It costs exactly the same at the beginning. The only difference is that the trademark office will not register your trademark until you're using the trademark in U.S. commerce, selling goods in U.S. commerce. So if we file that intent to use application in about a year, I'm going to be asking you, hey, are you selling this yet? And if you're selling it, we have to file a statement of use. And that is when you will see a difference in the fees, is that there's a fee to file that statement of use. Otherwise, everything is exactly the same. You'll see that the difference between the use and intent to use application is the use application. I need your date of first use, the date of first sale, and a picture of your goods of what you're selling in the United States. So it's really just about, are you selling it or not? If you're selling it, you have to show me and you have to give me the date. If you're not selling it, it's intent to use. And both work equally for Amazon, so it's not a problem. And that's what these are the 5 things that I ask you for right away when we start working together. So it's plug and chug from there. Next slide. Oh, I already explained this and when I was talking about the other stuff. But basically, use, when I ask you for use, you're going to want to send me your fancy marketing shots, and I love that you have them. But I am going to tell you to take out your cell phone and take a picture of it with your phone and send me the picture that you've taken with your phone on an email. The trademark office has gotten very strict about their specimen pictures. They want it to be a raw, non-marketing shot because there have been so many photoshopped specimens that have come into the office. And so we will get a rejection if we send something in that looks like a Photoshop, that looks like a digital alteration. That's what the rejection is called. And so I am going to be asking everybody to send me a picture with their phone. It doesn't need to be a fancy. I just need to see the mark, product, and I'm going to be very happy. So that is the best way to send it to your attorney. All right. This one, your moderators here asked me to talk about this a little bit. What other countries have IP Accelerator? France, Germany, Italy, Spain, Netherlands, and the UK have it. So you can use an IP Accelerator firm in those countries. And I've given you the link on the Seller Central for those countries. So I cannot file a trademark for you and have it work in those countries in an IP Accelerator type way. So you would want to use one of those firms in the EU IP Accelerator program to be able to get brand registry rights in those countries. And then there are some other countries that have very specific requirements. There is another link here that I've provided. You can go right there, and each country is listed. You click on it, it'll tell you the exact requirements that are necessary to get on brand registry. But IP Accelerator, this particular program really is only working here in the US. And then if you use an EU firm that's in that IP Accelerator program, you can have it work in France, Germany, Italy, Spain, Netherlands, and UK. Okay. I think next slide, which is all questions. I talked really fast because I wanted to make sure there was lots of time for questions here at the end.
Fantastic. Yeah. And of course, we are going to share all of these slides with everybody. So once the webinar is over, we'll post a link to the slides in the post description so you can get all of the links and also Tina's information. So Tina, thank you so much for that. That was very comprehensive. Let's see if we've got any questions. Okay, so someone is saying, will Tina be able to help us with trademark registration? And if so, can we get her contact details? Yes, we just mentioned that, but it's best if you want to sell on Amazon, go through the IP Accelerator program. So is it any different if people come to you directly or if they go through the Amazon IP Accelerator program? I mean, except that they get to use the map.
Yeah, if they go through Seller Central, they would just, we get an email, and the person who's working that day is going to be the one who responds, and will respond rather quickly. So emailing me at amazon@lozip.com or sending it through Seller Central is basically the same response time. Everything will be the same. The one difference is that when I report to Amazon at the end, if you're already in Seller Portal, you know, it's a little bit easier, but it doesn't matter because we can input it for you. It's not a big deal. So we're able to handle that. I will ask you for your Amazon seller email about 42 times during the process to make sure. That is literally the most important thing. Like, I can file 100 trademarks for you. If I don't have the right Amazon seller email, all hell breaks loose. So I ask at the very beginning, I ask when I get your engagement letter, I ask when I send you the filing details, I ask again before I file. It's very, very important. So don't be annoyed with me and say, I've already answered this. Yeah, I know, but it's so, so important. So seller email, very important.
Right. Okay, so this is Gayatri's question. I have a broad word mark, let's say ABC, but for various categories, I use ABC Home, ABC Baby, ABC Active, etc. Which one do we use to trademark, and how do we use for the various categories?
Well, one option is to just file for ABC. I don't know if you're using ABC in such a way that the secondary word, the descriptive word, because I'm guessing home is for home goods and baby is for, like, you know, baby clothes or whatever. But if you're using ABC, make that the more prominent portion of your mark, because I would want to file for ABC so you wouldn't have to keep filing each of those trademarks for every single thing that you do. I would want to file for ABC. But when I file for it, I need to be able to show the trademark office that that's really your main mark, and baby or home or whatever else it is sort of not, it's just a descriptor. So try to make that the more prominent portion of your mark, or include it in a logo of some kind so that it looks whatever, and then on the bottom it says baby or home or whatever it is. And that makes it a little bit easier to trademark. And then your Amazon brand name will be ABC. It will, because I will file it as ABC, it will be the Amazon brand name as ABC. So that's the best mark. Now, if ABC is super descriptive, then it falls under all the categories that we just talked about. But your descriptive portion sounds like it will be home or baby. So I'm guessing ABC is a more distinctive mark.
Right. Okay, so this is Rami's question. Is logo label sticker on carton box enough for the photo, or does it actually have to be on the product? I guess that's his question.
The goods or product packaging is fine. So it can be on the product packaging, but so if you're going to use a sticker on the box, though, make sure it doesn't look fake. Okay, so I don't know how to say that in a nice way, but the consumer has to be receiving it that way. Okay, so if you're sticking if you're getting a label from your printer that you just put an address on, and you're sticking it on a box and you're writing on it and you're saying, here's my label, I'm going to tell you that's not going to work. Okay, it has to be the way that an end consumer receives it. I've seen it all, folks, and I'm telling you that that's not going to work. Okay. It's got to be like an authentic use, the way that a consumer is receiving it. So if they're not receiving it that way with their label that's peeled from your printer and stuck on there, and you crossed off somebody else's address to get it on there, then it's not, that's not going to work unless it's an authentic use in commerce, right? So that's what we're working on. But yes, if it's on the product packaging, it should be fine. It just has to be an authentic use.
Right. I guess the ideal situation would be you could get it printed on the box, on the packaging.
Yeah, printing on the box is fantastic if you're using it. If it's engraved on the goods, if it's on the tags. For clothing, it's extremely important that you're not sending me like a brand on the front of a t-shirt. That's considered merely decorative. It needs to be on the hang tags, or on the on the tag at the back of the shirt, or on an actual tag, or on product packaging in some way. Sometimes Amazon sellers will put clothing in like a plastic, a pre-marked plastic packaging, and it has the mark on the plastic packaging. That works very nicely. A sticker on the product, as long as it looks authentic, is fine. But that's essentially what you're going. Pre-printed on the box looks good. Engraved on things. I just did one the other day where it was engraved on the goods. That works fine. Engraved on the bottom, engraved on the side. That works for metal products a lot. People will send me that. Ceramics, you'll see it engraved on the bottom of ceramics sometimes. Things like that. That works fine.
Right. Okay, so another question from Gayatri. My logo is registered with the Australian Copyright Registry and the Global Copyrights Registry. Is this useful in the IP Accelerator process?
Probably not. You'd have to file in the United States. And once you file in the United States, we could use that for the IP Accelerator program. I don't think that Australia has an IP Accelerator program at this time. And so it would not work unless you filed it through the US IP Accelerator program. And if you have questions on things like this, I would suggest that you also follow up with Amazon. I know trademarks really well. I'm a trademark expert, but I'm not an Amazon expert like you all. So, maybe ask Megla if she's like, I don't know, then go to Amazon, because Amazon, I don't have like a special secret person at Amazon who communicates with me. In case you didn't know, that person doesn't exist. So I'm also asking, I would be asking a question. So I would suggest that if you have a specific to Amazon kind of question, you should ask Amazon. It might take a while to get the answer, or the answer that you want, or you might get 3 different answers, but you will get an answer. and it's better coming from Amazon if it's related to Amazon. I can answer trademark questions pretty good, but once it gets to like, what does Amazon do in this situation? I don't like to speak for Amazon, because who knows?
Yeah. So,
and Tina, have you seen a lot of people now when they have sort of brand names, they're now keeping a brand name, or the mark or whatever, to a small, not too many letters, so that when they use it for their listing, it's not too big. You know what I mean? So it's like 4 or 5 letters as a brand name, or 3 or 4, rather than have like a 10-letter brand name, and then later on your listings, it's got all those letters.
I think that I think that most people like to keep it short, or keep it to 1 or 2 short words. It's much like a domain name. When you choose a domain name, you don't want to make it too difficult for people to remember, so that you're able to remember it if it's something that people buy repeatedly. And if it's too long or too confusing, or people can't find you again, or if it's too many weird letters that don't make sense and you can't say it, I think that that's usually not the most common thing that we're seeing. We're seeing mostly shorter trademarks, or a couple words that are easy to remember. That
like
seems
generic type words as well. I think
you don't want it to be totally generic, because you don't want it to be generic of the goods. So you don't want to just file for like water bottle for water bottles, right? Yeah. You want to try to find something that's slightly more distinctive. So when I hear generic, it means just like, what is this thing? It's a water bottle.
Okay.
But people are choosing words, things like Blue Lagoon or whatever, something that's easy to remember, easy to spell. Yeah. That's totally made up, I hope. So it's really just a very arbitrary mark that has to do with, that's just a choice for the or orange tulips, something just really arbitrary that people can remember that they're associating with their goods.
Yeah.
Yeah, and I think too, what a lot of people mightn't understand is you're supposed to, Amazon like you to put that brand name at the start of your title. So if you've got, the ABC Company of Australia or something, you've used half your title and there's no keywords in that because nobody knows who you are. You're not, Mr. Nike or Mr. Apple, so they're not going to ever start looking for that. So I think people should also bear in mind just from the if they're going to abide by Amazon's rules and put that name at the start of their listing, which, you're supposed to do, you're going to be wasting half your, 200 characters if you've got, 50 or so characters of, a brand description. Because I have seen some really long names sometimes and I think, oh, what a waste. But, it's too late once you've done it.
And I'm so glad that you've said that because that's really taught me something. Like I said, I'm not an Amazon expert like you all. You guys are Amazon experts. You know that you only have 200 characters. Now I know that. So when I see that come in from a client, I'm like, you just wasted 80 characters on this nonsense, right? Like you need to choose something that's a little bit shorter so you're not wasting your title. Yeah. So it's wonderful to learn from you as much as, like this is a great piece of information that I didn't realize that they're taking up room in their title when they do that. So that's great information.
Yeah. It's real estate.
So what about costs? Like how much does it cost to file a trademark?
Sure. So the filing fee with the trademark office is $350 per class. That went up from $275 on January 2nd. So I'm sorry to say that the PTO raised their fees just a little bit by $75 just a few weeks ago. But it's $350 per class. And then, firms vary in terms of how much they charge. And, I've sort of seen the fee structures for a few of the firms and I know that everybody includes different things. I don't know if you want me to be specific, Megla, about what I charge. I'm not sure. I don't want to do a hard sell or anything, but I can talk about it if you want me to. We do a flat fee. So that usually is pretty predictable for people. And I can talk more about it if you want me to, Megla.
Sure, I think that might be helpful. I mean, if you're comfortable.
Oh, yeah, no, I'm an attorney. I'm always comfortable talking about money. I'm kidding. So I do a flat fee because I don't want to talk about money. I just want you to know what's included, right? So I charge $900. It includes the search results, a summary of the search results, the preparation of and filing of the application, and then reporting to Amazon. That's all included in the $900. The only thing that's not included is if we file that intent to use application and you end up having to file a statement of use in the future, that will, we have to pay for that statement of use. So we're going to have some extra fees for that. But otherwise, $900 covers almost everyone. And then plus the filing fee of $350 per class. So one class, one trademark, $1,250 is the total.
Right. So what happens if you file for a trademark and then you start using it on Amazon, but it's ultimately rejected?
Well, we'll find out about a rejection about 3 to 4 months after we file. That's why we do a search. So we try to make sure that we've told you if we think that there's going to get a rejection. I'm telling everybody right now, I'm never going to say there's a 0% chance of a rejection. Okay. No attorney is going to do that because, we're all covering our asses, right? That's what we're doing. Because we don't know what's going to happen at the other end. It's going to a government agency with a person there who might have woken up that morning and they had flooding in their house and they're in a terrible mood and they got a ticket from the police on the way to work. They're going to look at your application. They're going to find some, I can't predict every scenario, but we usually have a pretty good sense of when you're going to get a likelihood of confusion rejection. We tell you, we give you a percentage and we say this looks like it's going to get it. It's high risk, medium risk. You'll know. If you get the rejection, we have the opportunity to respond. So we have 6 months to prepare a response. We'll again tell you, we have no shot at this thing. or we have a good shot at this thing. We think this is ridiculous, because we think you should have a good idea of whether we're going to be successful in a response. But yeah, a response does cost more money because it takes more time, right? So if we're preparing a response, it usually takes us a couple of hours to prepare it, 2 to 3 hours. So that's what you're looking at, is paying for our time if we get that rejection. But hopefully you're not getting a substantive rejection. We have pretty good success in predicting whether someone's going to get one. So if you get one, you'll know you're getting one when we file, probably, because we'll tell you. We'll tell you, this is a little scary here. You might get something, some people are like, let's keep our fingers crossed, roll the dice. And other people get really worried. So it just depends on how risk averse you are.
Yeah. And the good thing about that, Tina, is that whereas before people had to wait to join brand registry and all the things that used to happen along the way, sort of hijackers and things like that. I know you can't sort of keep complete hijackers away sometimes, but to go straight into brand registry, there's some benefits from that. So for people to pay that upfront fee, it gets them in the game quicker. In the Amazon space. And so if it's 6 months along the way, and then they sort of, they're probably getting a few sales. And if anything, you're going to fight, to keep that mark, then maybe you've got the money to be able to fight that mark then, instead of, beforehand, you're going in with, little or hardly any money. And then you're thinking, oh, if I lose it all now, I've sort of gone. So.
Well, what's interesting and what's kind of nice, I think, is that Amazon doesn't pull you off brand registry if you get a rejection. You get your rejection at 4 months.
Yeah.
You have 6 months to respond to the rejection before your mark goes abandoned. And that's when you're going to be pulled off of brand registry, is once your mark has gone abandoned. So let's say you have me file a response closer to the 6 month deadline. You have basically 10 months plus, however long it takes for the PTO to review it. Plus after that, you still get a final rejection. So you might be on brand registry for a year and a half, 2 years, until the mark is fully abandoned. Meanwhile, if you've gotten a rejection and you're there, you have time to pivot to say, okay, I got a rejection. I don't want to spend money on this. I'm on brand registry now. I'm going to choose a new mark. I'm going to start transitioning my mark to this new brand. So, and at this time, like you said, Kevin, you've been practicing. You've gotten you're a little savvier on Amazon. You know what you're doing. You're like, I've had people who've changed their mark because they've gotten savvier and they've said, oh, I learned this and I know this now. And I'm going to file it this way now. Like, they become more strategic in the way that they do things as they learn how to do it. Yeah. As they get advice from y'all, when they start hearing from you guys, they start to make good decisions, right? Yeah. So that's always helpful.
So let's take this question from Gayatri. Follow up on my previous question. I have my brand name as ABC, and I'm already using ABC Beauty on my packaging. And another category packaging ABC Home and ABC Trademark is good enough for A+ content on Amazon. Or should I consider changing the existing packaging for all categories with the new generic trademark name?
I need to see it. So it depends. It really, and I know that you're like, no, it doesn't depend. Tell me now. But unfortunately, I need to see what you're talking about. I think you should be able to, as long as the ABC part is the most prominent thing on your product, I think that ABC can be your Amazon brand name and can be used exactly as you're using it. But I'd rather see it to give you good advice. And it's really hard to do that without seeing it on the packaging. And I don't want, all right, you're coming to me.
There you go. No problem.
That's good. I'm happy to chat with you about it. No problem. That's problem at all.
Okay, so another question from Rami. Hi, Tina and Mark. I also heard that we can apply for Amazon brand registry by filing trademark pending to Amazon, not through the IP Accelerator program. Is that option any different from IP Accelerator, acceptance rate, speed, etc.?
So when I file a trademark, it's considered a pending trademark. Okay, right? So anybody, when they file a trademark, if you file it on your own, or if you have me file it, or if you have another firm file it, it's always considered a pending trademark. If you have an IP Accelerator firm file it, then it will definitely be on brand registry in 2 weeks. There is a pilot program I don't have the link with me right now, but I can send it to you, Megla. I'm sure everybody knows about it, probably sent it around. There is a pilot program where I think, I'm not sure if you even have to use an attorney, but you can file a trademark application in the United States and you enter it into the pilot program, and Amazon might let you onto brand registry through that pilot program. I don't know how effective the pilot program is. I've heard it's not horrible. I think it's just, there's no guarantees, right? So you might get on brand registry, you might not get on brand registry. And then you're not getting legal advice or anything like that if you're doing it yourself, right? So those are all things to consider. I don't know how effective it is, but I have heard people have success with it. So I don't want to say anything about it because I don't know I don't know how good or bad it is. So I think that I know people have gotten into it, and it's a good thing that it's happening. Remember that if you're from another country, you need to have a U.S. attorney filing for you. So there were rule changes. I want to say it was last year, but it might have been the year before because 2020 just is a big blur. But at some point, the rules change, and if you're not in the United States, you need to go ahead and have a U.S. attorney filing for you. A U.S. citizen is able to file on their own, file a trademark application on their own.
Okay, awesome. Well, guys, if there are any more questions, let us know, and we'll start wrapping up over here. Margaret, Kevin, anything that you want to add?
I'm also happy to, if they write questions on that Facebook link where you put stuff, I'm happy to answer questions. They can ping Loza on Facebook, and I'm happy to answer questions on Messenger. And then if you come in through Seller Central, my whole team is really, really good. I mean, they're all fantastic, fun to work with, good people, and they know their stuff.
We can also add you to our Sourcing from India Facebook page, Tina. And as those questions come up for any sort of branding, you can be our branding queen.
I would be happy. I would be happy to do that, be your branding queen. But you need to send me a little crown or something.
No, I'd just like to say to everyone who's listening to this, please do not just go to a lawyer who's going to save you $200 because he'll do your trademark for $1,000 and not go through IP Accelerator and wait 12 months. The mess and the trouble and the heartache that will cause you, $200 is nothing. It is just a no-brainer to use this, whether you use Tina or you choose just use another one off the list. But please do not just go off and waste a whole year, because I mean, in our day we couldn't do this program, and it took us 12 or 13 months or something to get our trademarks through. So this is so much better and so quick for everyone. I just think it's definitely a no-brainer. But also bear in mind now, you need to ask, are you getting a search done? Because you might save a couple of $100 and not get a search, and it's going to cost you and come back and bite you if it's not searched, and then you're in, down the track 4 or 5 months, and you've got to then pay a lot more money. So just look at it all and take all the hints Tina's given you, I think, because it's been awesome.
I totally agree, Mark. I remember when we very first started the process some years back. And it took a bit of a punt, didn't we, really?
It was a lot harder.
Which is, I mean, I wouldn't hesitate at using the IP program. Would not hesitate. No. Now, if I was just starting out, I would not hesitate.
All the firms are really solid, and I agree with that advice. I mean, I think that you could find really, really good IP firms. And, there are lots of IP firms that are not in the IP Accelerator firms that I refer to, and I think that are excellent firms. But the IP Accelerator firms do not know a lot about this program. They've worked with a lot of sellers. We have a ton of experience. I filed, probably just on my own over 1,000 marks just in this program. I'm very comfortable with this stuff. So, it is kind of helpful, I think, as a resource to use an IP Accelerator firm, because we're really well versed in what's going on, and hopefully are more helpful to you in answering your questions. But yeah, I mean, start as you wish to continue, right? So if you invest a little bit more at the beginning and it feels painful, it will be less painful later. And so the advice that you're getting from Kevin and Marg, and I'm sure Megla probably is like, yes, it's like, start the way that you want it to be. Really invest in it, choose a good brand, be smart about how you're doing it. And, you might have to give a little bit more at the beginning, but then as the process goes on, I think you'll find it a lot easier and it'll be smoother for you.
Right. So Gayatri's asking, what is the best way to contact you for the preliminary questions before I get into the whole process?
Yeah, Amazon at lozaip.com is right on the screen. So that will get me. I'll see that right away. And so we'll be able to respond to you there. Again, Loza on Messenger, through Seller Portal, all of those places all come to the same place, the same inbox. So you'll be getting us there.
So Tina, one question. The other day we got a friend. He's talking about sort of going to Europe, but he's got a US trademark. Now, you spoke a little before about the Madrid Protocol, right? So if he has a US trademark and he comes to you, for instance, could you sort of make sure that like he's through the Madrid Protocol that he would be protected entering Amazon European marketplaces?
If he goes through if he already has an application pending in the EU, hopefully he's used an IP Accelerator from over there. If he has me file in the United States, I can use the Madrid Protocol to designate additional countries, and so we can file in other countries as well, using as the United States application as the priority application, as like the first as the base, and then file in other countries from there. And that's typically what we do. So within 6 months of filing the trademark application, and we do send reminders on this, it's important. If you want to claim priority to your U.S. application filing date, that's a good time for us to file, designate countries under the Madrid Protocol to do, more international applications. And so we've often seen, in around that 6 month time frame, filing in, the EU, Australia, India, China, we'll start designating countries at that time, because I think that's when people sort of usually say, okay, I have some money to invest in this and I know where this is going. I think sometimes, unless the seller is really, really sophisticated, they're maybe not doing that so early in the process because budget is tight.
All right. So anybody with those particular things you just spoke about can contact your office and you can sort of arrange those things. Excellent. Fantastic.
That's great.
Right. So Chris is saying, sorry, came in late. Hi, Chris. We're wrapping up now.
Hi, Chris. I'm all done. I can't help you anymore.
you missed it all.
And look, I'd just like to say, I've actually referred a lot of people to Tina, and everyone's come back to me and they've had their trademark, and I've been able to do their A+ content and everything very quickly. So if you're looking for a really good service, I know this one works.
Thank you. I like the props. I appreciate it.
No problem. You're welcome.
Thank you.
Well, Tina, thank you so much for your time today. It was really lovely talking to you. And thanks a lot for all of the awesome information that you've shared with us today. So,
Thank you so much to all of you. This has been so much fun. I've had a lot of fun talking with you, and I hope this is helpful to all of your customers, viewers, sellers. I don't know the word that you use. Clients, agents.
We'll find a word.
Followers. Yes, friends, colleagues. I hope it's helpful, and it was so nice talking with you. I'm always happy to help, and please just reach out if you ever need anything. It was so great talking with you, and thank you so much.
Sure was. Thanks a lot, Tina. That was
fantastic. Thanks, Tina. It's really good.
All right, guys. Thanks for tuning in, and we will see you next week.